fallen to me to make the introduction. So this is Harry First, who is the Charles L. Denison Professor of Law at my school, at NYU Law School. And he's also co-director of the law school's Competition, Innovation, and Information Law program. His biggest claim to fame is that he's the person who hired me and started me on my career in academia.
That is true.
When he was the head of the personnel committee at NYU. Besides teaching, he's done a variety of other interesting things. He was an attorney at the U.S. Department of Justice's Antitrust Division. Antitrust is what we call competition law. He was a practicing lawyer for a while, Loeb and Loeb, pretty unusual. He was a Fulbright in Japan, and he was also a visiting professor there, so he spent 2 years in Japan. And he was chief of the Antitrust Bureau for New York State. New York is a very active enforcer of what you guys call competition law, so he had a very busy year. And he's co-author of a book called The Microsoft Antitrust Cases, Competition Policy for the 21st Century. So is that based on your experience doing the Microsoft case?
In part, yes.
Yes.
Fortunately.
So the inside story of the Microsoft case, for anybody that's interested.
And it's still on Amazon, I think, if you're, I don't know if you're really interested.
And he can get you a cheaper copy if you're really and ask him good questions. At NYU, he teaches antitrust law, comparative antitrust law, regulated industries, and when called upon, criminal law. He's also interested in innovation policy, particularly in the music industry. And together we've taught courses on the overlap between antitrust law and intellectual property law, and also a course on the topic that he's going to talk about today, which is IP crimes. So, Harry.
Thank you, Rochelle. How many of you are IP specialists? You're really... only one person's confessing to that? 2 people, 3 people. Criminal law end? Any from the criminal law end? People just dropping by because you're going to have drinks afterwards or something? I don't know. There, okay, good. So as Rochelle's introduction makes clear, I really don't teach intellectual property. What I do is when we co-teach, she teaches the intellectual property part. So anything about intellectual property law that I say, I learned from Rochelle. And if it's wrong, there we are, she's here. This talk grows out of a course that a seminar actually that we started a few years ago on criminal intellectual property law. And every time we say, oh, we're doing something in criminal intellectual property law, everyone goes, whoa, that sounds interesting. And maybe that's why you're here, because you're trying to figure out what actually it is. So are we to some extent. This is an overlap that I think I can say safely is not explored either on the criminal law end or on the intellectual property end. So a lot of the discussion arguments over intellectual property are about the scope of intellectual property rights, too broad, too narrow, and how it works out in the various different kinds of intellectual property. But very little, if anything, about this part of the remedial structure. Sometimes very little about remedies maybe, but certainly on the criminal end. From the criminal law end, crimes rarely gets to economic crimes and rarely gets to these kinds of crimes. So this is in many ways, I was going to say an understudied or a non-studied area, which we are sticking out as our own because no one else is foolish enough to do that. But this is part of that effort, and it's an effort in some sense to put together a field, raise some of the questions, and hopefully for all of you give you a sense of, at least my view of it. I won't force Rochelle to agree with everything, but at least my sense of it from the US perspective. And I'd love to hear, of course, your comments and your views from your own perspectives. So the talk tonight, is this going to work? It was just working. Why is it not working? Hold on. And Rochelle said that I did this. Well, just Where are we here? Why is it not working? Did I not do something
There's
right?
the arrow.
Yeah.
There it goes. It goes.
Okay. Yeah, there we go. All right. And now we're going to like that. Okay. Sorry. Since I wrote that book on Microsoft, no Microsoft program works right. Now, I don't know. They're a really good company. So here's the organization of the talk. I want to start out with a little introduction. I'll give you six cases, count them, 6 cases, just to get you thinking about the kinds of issues that arise in this area. Then I'm going to give a little sense of where we are. And this, again, is from a U.S. law point of view, but some of this, I'm sure, has overlap here. Third part, how we got here, a little bit of history, a little bit of political economy to explain sort of where we are in this area. And then how to think about intellectual property criminalization, a little bit on criminal law theory, and, of course, a conclusion. Hopefully we'll get to that. Okay. So 6 cases. Case 1 is the greedy programmer. So this is a story about Sergei Lenikov, who was a programmer for Goldman Sachs. How many people have heard of Goldman Sachs? Thank God. Okay, right. Yeah. So now you know the world you're dealing in. Helped develop the computer source code for Goldman's high-frequency trading system. This is trading stocks high frequency, making a lot of money. So Goldman was very interested in this. He was working on the source code. Gets hired by a firm that wants to enter the business, a new competitor. Gets hired at multiple of his salary, over $1 million, to help develop the new company's own HFT system. On the day of his going away party, just before he goes away, he downloads source code for the HF, at least a major part of the HFT program, uploads it to a server in Germany, and then goes out to have his going away party. Then comes home, downloads it to his own computer at home, subsequently takes some of the code with him to a business meeting in Chicago, flies back, gets arrested at the airport. And some of the code was proprietary, Goldman's own, some was open source. I put that in quotes, never quite clear what all of that means. He said, I just wanted to take the open source information to review it like a person would in college, to go back and read a paper. Okay? And he later realized he downloaded more files than he'd intended. So this is what he told the FBI, actually. So the question at the end is, has he committed a crime? Case 2 is the Elvis fan. How many people have ever heard of Elvis Presley? Always like to check with the audience. I check with my students at home too. You know, I think at some point they'll say, who? Okay, so he's yes, he is still alive. Rochelle used to live in Nashville. Okay, so Dowling is an avid collector of Elvis recordings. He makes and distributes previously unreleased, never been heard, Elvis Presley recordings, so-called bootlegs. He wrote the liner notes for the albums and designed the covers, studio outtakes and concert tapes, Rockin' with Elvis New Year's Eve, and TV performances, Elvis Presley from the waist up. If you don't know what that is, I'll explain it later. RCA Records had an exclusive contractual right with Elvis Presley to distribute his performances, these performances. Most of the songs were copyrighted, under copyright, but the performances actually at that time were not protected by copyright law. Ships thousands of albums in the U.S. mail. What crime, if any? That's case 2. Case 3, the password abuser. You should sit there and take notes on this one in case it rings home. David Nosel is an executive at an executive search firm. He decides to leave to start a competing business. He signed a blanket non-competition agreement, unclear even how long it was supposed to be. But before leaving, he uses his password to access a database of information on executive talent and do some searches for his own. After leaving the company, company revokes his password, as all companies do when you leave. But he borrows his former assistant's valid password and uses it to compile a further list of prospects. The database, as you know, not protected by copyright law. Same question. Case 4, the altruistic information sharer. This is about Aaron Swartz, an internet activist. Here's what he wrote in the Guerrilla Open Access Manifesto. We need to take information wherever it is stored to make our copies and share them with the world. How many people agree? Don't, okay, you don't have to decide this yet. He accesses something called JSTOR. Do you know what JSTOR is? It's a database of a lot of scholarly writings, which this non-for-profit company licenses to universities and research companies. He downloads 4.8 million documents through an academic account, but in violation of terms of service. Major portion of its archive, none actually gets distributed. Some of the publications are in the public domain. JSTOR, after finding out about this, says, quote, our interest was in securing the content. Once this was achieved, we had no interest in this becoming an ongoing legal matter. So they released that statement. And the question, if you were the prosecutor, would you indict Aaron Swartz even though JSTOR said that? Case 5, the baseball cheats. How many people know baseball? I was worried, because if you had given me rugby, I wouldn't have a clue. The Houston Astros, Major League Baseball team, use in-game live TV feed to log the catcher's signs, the signs they're making to the pitcher, they put that and the actual pitches into an algorithm-enabled Excel spreadsheet, actually, to predict the next pitch. Information is relayed to the players in the dugout, who would bang a trash can with a bat to communicate the upcoming pitch type to the batter. People started wondering, why is there so much banging in the Astros dugout? Program they called internally Code Breaker. And it was a violation of Major League Baseball's rules. Is it a crime? And 6, the clever railroad workers. So, A, Chief Mechanical Officer of the railroad, asked by the CFO of the railroad to prepare a list of all railroad rolling stock, takes the visitors on tour of the rail yards. B, who's a train man at the rail yards, notices an unusual number of yard tours by people dressed in suits. A is a longtime friend of B's father and married to B's aunt. Why that's relevant, I have no idea. But it's sort of fun, isn't it? A, B, and family friends predicting the coming takeover of the railroad make $1.6 million trading railroad options. Is it a crime? Got it? So we have 6 cases. You want to try to juggle those, keep those in mind. I'm actually going to give you the answers. This is not like law school. In law school here, do they give you any answers? I hope we never give answers. I only ask questions, but I will give you the answers. Common threads. Cases all involve information or information products you could think of whose dissemination has some social benefits, but may also harm the original producer of the dissemination. Cases involve different means of acquiring the information. We'll come back to this. Cases implement a variety of laws, and I'll indicate what I mean, many of which were enacted with different technologies in mind. Prosecutors in the U.S. and here as well, I assume, have broad discretion on what charge to bring or whether to bring criminal charges at all. So there's a lot of discretion built in. And of the 6 cases that I gave you, 5 of the 6 resulted in some or many charges. Now you should be thinking, which one didn't? But I'm not going to tell you yet. Okay, so where we are, scope of intellectual property crime. Do a taxonomy of IP crime, some inventory of U.S. IP crimes, and some U.S. enforcement data. Get a sense of the lay of the land. So the closest analogy here, and it's probably one that sprung to mind as I'm going through these 6 cases, is theft. Right? Improper acquisition of other people's property causing economic harm to the victim. So you could think back to case 1 with Alenikov. But how about case 5 with stealing signals? Theft. Is it theft? So that's in many ways the go-to analogy from the criminal law. Of course, a question how well or closely that works. Within theft law, how many of you took criminal law? How many of you remember criminal law? Okay, yeah, all right, good. So there are three, basically, as the criminal law developed, I'll talk a little bit more about this, three different types of improper acquisitions of other people's property, three main categories, which look at the different ways you can acquire property. So one is sort of larceny or stealing. Originally sort of was a forceful taking out of possession, taking out of possession and depriving the owner of the property permanently. So that's the core of what theft law was and how it's developed from common law. Fraud and deceit, deceiving someone, telling them some sort of lie to make them part with their property. So you don't take it from them physically, but you deceive them and they give it over to you. Third is a breach of trust. You get property in a situation where you're entrusted with the property and you then take off with it. Think of it as embezzlement. So three different types. The possessor, the owner of the property, is without it at the end, but three different ways of acquiring it, and the criminal law is distinguished among those three. So a little inventory of IP crime, sort of keeping up with that trichotomy, if you will. So stealing, taking. We can think of copyright infringement. I'm not going to ask you how many of you have downloaded music. People are already smiling without permission, but that's one of the questions. So in U.S. law, willful infringement, there's always some intent requirement, as you remember from the criminal law, and for the U.S. for purposes of commercial advantage or private financial gain. And a second kind is knowing distribution of bootleg live performances. So you sit and you make a copy of a performance being done live, Elvis Presley live, and you distribute it. And then something called the Digital Millennium Copyright Act, which talks about the circumvention of technological measures to protect something. So something has some code that's supposed to keep you from copying it, and you figure out a way to circumvent it. That's also a way, in some sense, of taking it. No force exactly, but there is some taking. A second one that is used is the National Stolen Property Act in the U.S., where it's knowingly transporting stolen goods. So this can be used also for intellectual property crime. Second kind for deceit, or use deception. So in trademark Counterfeiting Act, which the U.S. passed in 1984, which is intentional sale or trafficking in goods with counterfeit false marks. So it's not quite the same thing as trademark infringement. It's selling something with a false mark on it. I want to ask you how many people own a Rolex here, but if you do, it's probably got a false mark on it, but then you know that, right? So trademark counterfeiting. For patents, the third major intellectual property laws, there is no criminal provision for a violation of, basically for a violation of patents. Maybe for getting a monopoly through fraud on the patent office, never been prosecuted. So the U.S. does not make willful infringement of patents a crime. Some other countries do. So there are distinctions there. Right, but this is, I put this in deception because there's a legal patent marking, which can be a crime, but not to worry. Third is abuse of trust. So here list three main kinds. So trade secrets, where you are entrusted with or get given trade secrets and you sell them. You willfully get them, sell them, and so forth. There are two kinds under U.S. law. One is to benefit a foreign government. It's called economic espionage, and I'll talk a little bit more about that. The other is to knowingly injure the true owner, just straight theft. It's called theft of trade secrets, but often it involves an abuse of trust. You've somehow gotten trust from the trade secret owner, and then you take it away. Maybe Alenikov, as we think back to case one. Second, misappropriation of confidential information, securities fraud. So this is not what we often think of as intellectual property crime, but it is an information crime in a sense. You use information that you've gotten maybe under conditions of trust. You're an employee, and you misuse it. You misappropriate it, not the way your employer wants, but the way you want for your own purposes. So that's case 5 or 6, maybe it's 6, the clever railroad makers. Is that a crime? And it can be prosecuted as securities fraud or something more general called in the U.S. mail or wire fraud, simply using the mails to defraud. And then the final one, unauthorized access to computer systems, which we colloquially call hacking, getting into some computer system without authority or in excess of authority, and then taking something away. So that's a broad sense of the field, the scene in the U.S. A lot of different statutes, often with different penalties, and sometimes, often, different requirements. But it's a basic sense of the field of what's involved, at least on a federal level. To further complicate the matter, we do have these things called states in the United States, and states often have their own set of laws as well that might be implicated. So I'm just basically concentrating on the federal, but just sort of keep that in mind. Now, if you want to know if this is an important area in the United States, my bottom line answer is yes, sort of. But here's a little data for you. Data, always good to have. It gives you a sense of how many cases there are sort of being generated in the federal system. And this is a set of crimes called intellectual property crimes, which won't go through the way the Justice Department has defined it. There may be more crimes than this in some broader sense because not supposed to cover just straight conspiracies. Sometimes these cases are indicted as conspiracies. So AUSA is the Assistant U.S. Attorney. That's the basic line prosecutors in the federal system. And you can see in this, I was sort of surprised by this. The numbers seem to be declining in the United States. See, my pitch to you was this is an increasing area, becoming more and more important. And then I looked at the data, and now I've got to make up a story. But so there seem to be somewhat fewer cases from 2014 to 2018, fewer defendants charged, fewer cases, fewer defendants sentenced. A couple of the interesting things, which may not surprise you in some sense. A lot of these defendants who are convicted never go to jail. So if you think of the criminal, wasn't it Dostoevsky, crime and punishment, isn't that supposed to go together? Apparently for federal judges, quite a large number never get any prison sentence. A fair number get low sentences. Not that I would think any time in jail actually for me is low, but 1 month to 12 months, you can see the numbers. Over 5 years, very few people. So the rap about the U.S. Justice system, criminal justice system, often is too many crimes, too much time. In this area, there are a lot of crimes, but the numbers prosecuted seem to be not quite so many, and the jail time is low. Whether that's correct or not is a good question on both ends. And here it is by type, so you can really get some sense for intellectual property crimes. So most of the crimes that are prosecuted in this area are trademark counterfeiting. So look at your Rolex again. This seems to be the largest percentage. And I'd love to have your view, your sort of sense of why that might be so. For copyright violations, you can see from 2015 to 2018, the number's actually decreasing. There's something called counterfeit labels. If you put a counterfeit Elvis label on, I guess you could be prosecuted, separate statute. But the number of copyright cases going down, these are cases charged. Economic Espionage Act, this is the trade secret area. So 2015, there were 10. 2018, we've got 11 total. This is an area, and you very well may know this, which actually I think is trending upwards. And we'll talk in the end about why that might be so. So in total numbers, it's not a huge number. You can, not sure what to do with this one. So if you do something to migratory birds, you're much more likely to be charged than copyright criminal copyright infringement. And the big three, of course, I mean, just totally, you get a sense of what the U.S. justice system looks like, right? This is it. Immigration, drugs, and firearm offenses are the big three by numbers by way far. Again, whether this is correct or not, whether it reflects economic impact or not, is a good question for us as we're thinking about this area. So my bottom line is it's important, maybe becoming increasingly so, but not in huge numbers in the United States. But that doesn't mean we shouldn't study it, because it is interesting. And of course, there are various views of social norms. You might have seen this difference between theft and piracy. All right, theft removes the original, piracy makes a copy and leaves the original. Piracy, imagine your car gets stolen, but it's still there in the morning. All right, is that theft?
So that plays on a very,
what?
There's the Singaporean IP office, sorry to intervene, but the Singaporean IP office used to run the slogan where they had like a commercial, and it ended up saying you wouldn't steal a car either, because they were making the argument that copyright
is it? Yeah, that may not be the perfect one. You might think instead, if you're going to have a slogan, piracy is not a victimless crime.
Right.
You've seen that. So this is a little cartoon to make us think about that. You can view this cartoon in many ways. The people on the left are the real pirates, who are the ones on the right. Or are you really going to scare people away by sticking your tongue out and saying piracy is not a victimless crime? But the deeper message of that is this connection between social norms and criminalization. So how do we think about these as crime? And, the question in all those examples was, are these crimes? How do we think about it? So a little bit of how we got to where we are, because in all the federal statutes that I've pointed out, even though they're not invoked all the time, and maybe not in large numbers, they're still there as crimes. So how did we get to this point where these things are defined in the criminal code as crimes? So it involves a little bit of legal history, political economy, and intellectual history. So legal history of theft law, and this is a quote I like, which is why I used it, of course. The book is called Theft Law and Society, a really interesting study of theft law by Jerome Hall. And practically the entire modern law of theft has been a product of the 18th century. So sense of history. But he's right. There was a case, 1799. These are all English cases. I want you to know that there's some, English element to this. These are all English cases where it comes from. Baisley's case, the lawyers in Baisley's case set out this three-part difference between larceny, deceit, and fraud, taking by artful device against the subtlety of which common prudence and caution are not sufficient safeguards, and breach of trust. The owner is put into possession of the trustee without any fraudulent seducement. I like that language. So the basic, and Baisley was a bank teller, and He was also the treasurer of the Ding Dong Mining Company, private concern. And someone came in with a deposit to put in the bank. And they hand him 130 pounds. And he takes a 100-pound note of that and puts it in his pocket and puts the 30 pounds in the drawer, the cashier drawer. And the question is, did he commit any crime? All right. He didn't take anything. He was given it. It wasn't in the bank's possession because it was in his own pocket. So he didn't embezzle anything. And he didn't engage in any deceit because he didn't say anything. He was just standing there. So the judges said, no crime. Parliament in six months, 3 months, passes a statute making what he did a crime. So before specific kinds of banks, there were special statutes for embezzlement. After Baisley's case, it was a general statute. And I point this out not just because of the nice language that the lawyers used, but because it shows a pattern in this case which moves us from sort of history into action. So very often judges are conservative about this, not always, but are conservative about moving the criminal law into these new areas. But the legislature is not, because Parliament responds quickly. And in a number of the cases in the US, it's the same kind of effort, even though the judges may acquit because they don't want to push the law and they're conservative. The legislature reacts. So why might that be so in the area in banks? Okay, banks are important. The economy at the time, this is the turn of the 18th to the 19th century, very important to the economy in England, moving from a guild, sort of an economy run by guilds to more market-oriented, more impersonal markets. We've got, I have this in here, coming up. And the judges, either the judges respond or the legislature responds to give protection to property interests. And that's, in this economic area, an important part of the history and the political economy of what's going on. So the Horses case, this is Pear's case from 1779, another sort of great puzzler for the criminal law. Pear goes to rent a horse from someone. The owner gives the horse over. He's going to rent it for the day. But of course, Pear sells the horse. And then he's indicted for larceny. And he said, I didn't take anything. You gave it to me. What do you do? And there, actually, the judges drew on a way older case, which seemed to imply that fraud supplied the force. And they said, okay, we'll call it larceny. And my reaction when I read this case is, it's horses, stupid. I mean, if you're going to protect any property interest, this is an interest that can run away. So, and is very important. So yes, the court moves to protect it. So there the court protected the property interest, the legislature protects it. In Baisley's case, finally on the end of deceit, you see the courts shifting in the 18th century from a real caveat emptor idea to, and Parliament moves us along too, to protecting consumers, even gullible ones. So in Young's case, the defendants get some guy to bet on a race. They've got a sure bet it's going to run tomorrow. He's going to win, and they dupe him. There was no race. There was no sure. There was nothing. It was, as the lawyers said, a bald-faced lie. And the court said, well, Parliament's decided to protect that, even the gullible. So we move in a market economy to put these protections in and to use the criminal law to some degree to reinforce those protections. So that's the political economy part. The intellectual history part, again, I think the importance of the 18th century, sort of 17th through 19th maybe, where a utilitarian view starts to really emerge, a Benthamite view, if you will, against John Locke and some sort of moral rights or deserts view. You're entitled to the results of your labor. So do we have these laws for instrumental reasons, to advance the interests of society, or because we're protecting some moral right? This sort of fights out in this period between those two, and comes out, I think, in intellectual property as well. On the utilitarian part, there's this tension between thinking of intellectual property, as a right, sort of this is yours, maybe more towards a natural rights point of view, but also then a concern for monopoly. Is it a right, or is it a privilege that we have for utilitarian reasons? And so we'll think about whether enforcement in particular areas is best for society or not. So there is that tension that emerges in intellectual property and in the criminal law. Now I want to overlay that with some sort of what we would today think about the economics of intellectual property, which I assume you know well. It's a great quote. Thank you, Rochelle, for this, from Jefferson. You know Thomas Jefferson. I mean, you don't know him personally, but he said, I love this. He who receives an idea from me lights his taper at mine, receives light without darkening me. Ideas should freely spread from one to another over the globe for the moral and mutual instruction of man and improvement of his condition. Very much a utilitarian view, sort of intellectual property as public goods. And it's the car that's still there while someone else has it. It should be, not just that it can be, but should be transmitted widely. There's strong public policy in dissemination. So these things are a little at war in the criminal law as well. So we have the benefits of dissemination and the question of, is there, even on a strict utilitarian point of view, harm to the original holder of what we could consider loosely that right? And Jefferson said, give exclusive rights to profits only as encouragement according to the will and convenience of the society. A real utilitarian viewpoint. His idea, apparently, of this lighting your taper at mine, I found that he was not the first person to write this, actually. I always thought he was. It goes back sort of centuries. So an interesting idea about this. So how do we think about intellectual property criminalization and criminal law theory? So let's see how we're doing for time. Yeah. Purposes of the criminal law. Now I feel better now because most of you don't remember your criminal law, and that's good. So I can tell you most anything. The IP part, you're saying, what? But this, okay. So general purpose of the criminal law. But again, we have this tension between some sort of moral intuitions we have about the criminal law and utilitarian point of view. So the retributivist view, you get punished for blameworthy behavior. You did something wrong, right? And you get your just deserts. Not dessert, but deserts. Right? You get what you deserve. So there is that normative sense, a retributivist sense, of what the purposes of the criminal law are. Utilitarian is where we want to deter costly social behavior. Right? If it's costly and we can deter it best by using the criminal law, we should. It's utilitarian justification for criminal law. Now, often those two things can ride together for particular crimes. People can find both of them, but sometimes, and particularly in this area, I think they may be in tension. So in intellectual property, for blameworthiness, there is a sense that if we criminalize something in some kind of taking of intellectual property or misappropriation, sort of more generally, there is an expressive function to this. So it says it's society's condemnation of that behavior. And may help to create a norm that it's inappropriate, that piracy is not a victimless crime, meaning that it is a crime. Right? So there is some norms creation. And hopefully, well, people who want to move towards, if you want to move towards criminalization, you may hope that by criminalizing something, you do show social opprobrium and you do start to convince people that that's wrong. The second part, of course, is deterrence. Maybe this can all ride on the notion that using the criminal law is a more efficient way to achieve the utilitarian goals of intellectual property law. So maybe that's good justification. Maybe they can both ride together, and so people who like one theory or the other can both be happy, but it may not always be so. So on a utilitarian calculus, you could say, well, so okay, why use the criminal law? Why not civil remedies? So for any of you who've studied intellectual property law, you probably generally think of this, if you're going to have enforcement, it's damages by the party whose right you've infringed, maybe an injunction to stop them from doing it in the future. But why do you need the criminal law? To throw in another kicker, all the statutes that I mentioned, except for the National Stolen Property Act, I guess, all the federal statutes that I've mentioned have civil enforcement and criminal enforcement. So the victims can sue and the government can bring a criminal case. And actually both can do it, just to keep lawyers employed. So why not just have civil damages? So a couple of reasons. I've listed some. It's the difference between prisons and fines versus monetary damages. So monetary damages, and sometimes people say this as fines, they're just prices. So you price it into the behavior and it may not deter at all. If it's just single damages, it's probably not going to deter because the party will do it multiple times. So you will get under deterrence. Prison. Okay, no more. So that's many people consider that a pretty potent deterrent. Doesn't seem to deter everybody. We still have lots of wealthy people in jail, white-collar criminals in jail, who apparently were not deterred by the prospect of criminal enforcement. But jail is, generally considered fairly effective. Second part of this is that defendants may be judgment-proof. If a defendant doesn't have any money left, or defendants who have very little money, civil damages may not deter them or future defendants who are impecunious. Some defendants are what I think of as judgment preferred, so people will sue people with deep pockets, maybe rather than the actual party that engaged in the behavior, or not all the parties. So again, some under deterrent story. And then finally, damages reflect private harm, but not social harm. So the social damage may be quite a bit larger. So you could argue that criminal penalties should be designed to take account of the broader social damage. So you can do that in part through fines and in part through through jail time. Okay. And efficiencies in government enforcement. The government can investigate before charging in ways that private parties cannot. And you can have, it's sort of like a class action, but you can have a single prosecution instead of multiple cases. So in that sense, it may be more efficient. How about retributivism? Does it fit with the criminal law? And this is a problem, I think, to some extent. This is a quote from Justice Jackson, Supreme Court. Crime requires the concurrence of an evil-meaning mind and an evil-doing hand. So does that really reflect those 6 cases we saw? Maybe some of them, not all of them. But this is often true in all economic crime. And as part of the retributist view, is this something really evil? Is it something really worth calling crime? And I think our views change about that over time. This goes with the expressive function of norms creation. Intellectual property norms, look, they're already leaving. No, it's good to see you again. Yeah. Intellectual property law itself has a lot of contested issues, right? So do we want to, how far do we want to go in making those things into crimes? But there are examples of where prosecutions have turned the sense of what's appropriate that had existed into one that it's not appropriate. And the area that I like to point to is in cartel prosecutions. I like to point to it since I teach antitrust. But 30 or 40 years ago, you could find a lot of statements saying, oh, cartels aren't so bad, we don't mind them so much, maybe they're good. Now there's a really pretty uniform judgment around the world that it's crime to fix prices in bid rigging. And that changed because governments brought prosecutions. So there is an expressive function that does help to change norms. Institutional issues are a problem. Criminal process is different from civil process, different burdens of proof, different ways you investigate. There are different enforcement incentives. So once you open up the idea of criminal enforcement, the parties harmed may have an incentive to try to convince the government to bring cases. In other words, to capture the government. This is a danger that prosecutions could be brought inappropriately. Fairness in the rule of law. Do defendants have good notice about what's illegal or not? Or the statutes are generally not perfectly clear, shall we say? On the criminal law side, you'll find judges struggling with this issue about whether the statute's clear enough. And then finally, the most interesting struggle in this area is between the criminal law interests in fairness, rule of law, norms creation, and the intellectual property interest in innovation and in that dissemination of information. So if all of these cases, involve some social benefit actually from getting information out, there may be, competitors entering the market. There may be information that just should spread and is inappropriately being confined by the intellectual property holder. And that tension between what you're trying to do on the intellectual property side and on the criminal law side may make these cases more difficult to decide. Policy goals. I want to bring back an issue that is front and center now and may explain some of the trends in intellectual property criminal law, which is a political economy issue. Again, economic interests wanting to use the criminal law to support their economic goals. So right now in the United States, criminal IP enforcement is become a part of trade policy. And anybody ever heard of Huawei? If you haven't heard of Huawei, you're just not reading the right parts of the newspaper. So the whole trade secrets area has become, they're stealing our intellectual property. They're stealing, this is the common use of the word, our intellectual property. It's about trade secrets, and it's about the U.S. View of what's going on in relation to China. So this is, again, it's not an ahistorical example. We protected the horse, we protected the banks, and we're now going to protect Silicon Valley. And it presents interesting questions of prosecutorial policy and criminalization. Do we think they're doing something wrong, that these really are crimes? Or is it sort of politics filtered through criminal law? So for criminal law policy, I think, we want to look at a harm principle. What's the harm? And not just the harm to the owner of the IP right, but to innovation. Because I think that in the end is a goal for intellectual property law. So that should be part of the harm principle that prosecutors think about. and a rule of law issue. So this may not be an area to push the boundaries completely, but to look for what was referred to in the antitrust area as the hardcore. The things that we clearly recognize in part for utilitarian reasons, but maybe in part for retributivist reasons, clearly recognized as crime. And we need maybe more sort of institutional capability on the prosecutorial side to understand the technologies that this may lead us into. So you want the answers, and then we can have questions? This isn't going to actually satisfy you all that much, of course. Case 1, the greedy programmer. So Alenikoff was convicted at trial for theft of trade secrets and national stolen property. I would put that to the side. The Court of Appeals heard oral argument and, in a really rare thing, reversed the convictions from the bench. Now, in the U.S., judges never do this. They write their opinions first. They said, this is crap. And they threw the case out. Opinion to follow. New York State then indicted Mr. Alenikoff under New York state law for the same behavior, and his conviction in the end was affirmed by the highest court in New York. You can read the cases. So split decision. Not funny to Mr. Alenikoff. Okay. Case 2, the Elvis fan. So this case went to the Supreme Court on a National Stolen Property Act. Can you transport copyrights across state line? Is that stolen property? So it wasn't, the albums were, the vinyl wasn't stolen. Well, copyright was stolen. And the Supreme Court said, no, it's not a violation of the National Stolen Property Act. He was also convicted of copyright crime, willful infringement of copyright for commercial advantage, and that he never appealed to the Supreme Court. So sort of a mixed verdict there, 2 of them. Okay, 3, the password abuser, David Nosel. So the first password where he had authority to get into the database, but he exceeded the authority, so the claim was, because he wasn't supposed to use it that way. The Ninth Circuit Court of Appeals throws it out, said, oh my God, this is too far-reaching on abuse of passwords. Has anybody ever abused passwords in this audience? Right, people are raising their hand behind you if you can't see. But the second part, where his secretary, he'd already left and had his password revoked, and his secretary did a search, they got him on that. Said, well, you can't use the back door to do what you can't do with the front door. You didn't have authority. You're done. That's on the Computer Fraud and Abuse Act. Split verdict, in some sense. The altruistic information share. The guy who said, JSTOR said we have no problem. We're fine. It wasn't never distributed. He was indicted for a Computer Fraud and Abuse Act for exceeding the authority he did. There are more cute facts in this. He was never tried. Unfortunately, he actually committed suicide in jail. Okay, this was a sad case. The baseball cheats. Watch the papers. It's still, and there is an article, I should have given you the site, that was written by one of the students in our seminar on stealing signals, that concluded that just stealing signals probably wasn't a crime, but there's a lot of data in baseball, if you don't know, and there are cases of really sort of taking databases to other teams. That might be a crime. So this is still an interesting ongoing thing. We don't actually really know the full facts yet. So the 6th one, the clever railroad workers, they were sued by the Securities and Exchange Commission for insider trading, but civilly. They were never indicted criminally. And the jury voted in favor of the defendants, and the SEC lost at trial. It was like, seriously? But, alleged the Securities and Exchange Commission, thought that this was an abuse of trust, that they had this information and they abused it. These people were not unsophisticated. You trade stock options, $1.6 million in stock options. Are you that sophisticated? I don't think I am, actually. So this is interesting, not quite a split verdict, but the 6th case, as I put these together, it shows really the difficulties in this area and to some extent the ambiguities, because these cases come out in some ways oddly different, even internally, and do raise sort of difficult borderland questions, both for intellectual property and for the criminal law. Questions, we have 4 minutes. No, we have 3 minutes. My watch says 1 minute, but no, anyway, if you, so thank you very much.